Our guest today is Lord Jonathan Sumption, one of the most distinguished legal minds in the United Kingdom. A former justice of the UK Supreme Court, he built a legendary career as one of the country's leading barristers, arguing many of the most complex and high-profile cases of his generation. He is known not just for his sharp legal mind, but for his clear voice on the limits of judicial power, the risks of courts drifting into politics, and the fragile link between law and democracy. His books Trials of the State and The Challenges of Democracy warn how declining trust can erode both law and democratic institutions. Beyond the courtroom, he is also an acclaimed historian, celebrated for his multi-volume history of the 100 Years' War. Today he joins us to explore trust, courts, politics, and the future of democracy. Your host today, Severin DeWitt.
Jonathan, before we dive in, I just want to say I've really been looking forward to this. You've had such a remarkable career, and what I've always appreciated is how openly you speak about things many judges tend to avoid, namely the limits of judicial power, the risk of courts drifting into politics, and that fragile balance between law and democracy. So welcome to Trust Talk.
The basic problem is that the courts are there to keep governments within the powers that the law allows to them. That is an entirely legitimate exercise for any constitutional court. Sometimes that means not only asking whether the government has power to do something at all, but whether it has power to do something in a particular way or for a particular reason. Now, the problem is that there is a rather opaque line between cases where the government is said not to be entitled to do something and cases where it is entitled to do something, but the courts disapprove of what it has done. I describe the line between those two things as opaque. That is certainly the position in English law. But at the same time, there is a line. The fact that the line is quite thick and that it is difficult to draw doesn't mean that it doesn't exist. In the past, the British courts have certainly crossed that line by such a large margin that it's very easy to say that they've drifted into the area of political policy, for which politicians should be responsible not to the courts but to the electorate. Recently, there has been a corrective in the United Kingdom. The courts have retreated from some of the more extreme positions that they previously occupied, and that is something I welcome. But the process of crossing the line is very clearly illustrated by the case law of the European Court of Human Rights in Strasbourg, which routinely decides questions which are undoubtedly political and which in a democracy belong not to the courts, but to elected legislatures.
I'd like to move a little bit on to the United States. I'm a great fan of the journalist Ezra Klein of the New York Times. On his show, he spoke with Kate Shaw, a former U.S. Supreme Court clerk, now a law professor, who argued that the court is no longer just interpreting the law, but actively reshaping American democracy through its rulings. In your book, The Trials of the State, you warned that law risks becoming what you call the continuation of politics by other means. Do you see the U.S. Supreme Court as an example of what you were warning about, courts drifting from legal interpretation into political power?
Well, I do. I think that it is necessary to bear in mind some of the particular characteristics of the Constitution of the United States, where three branches of the states, the legislature, the executive controlled by the president, and the judiciary, were deliberately designed as co-equal branches of the state, designed to keep each other in check. And therefore, the phenomenon which you have just described is actually a very ancient one. In the 1830s, in his famous book, Democracy in America, Alexis de Tocqueville, French sociologist and political philosopher, said that in the United States, every political question sooner or later becomes a judicial one. So this isn't entirely new. I think it is fair to say that in the 20th century, the United States Supreme Court was a very political court. Its politics tended in different directions. In the last years of the 19th century and the early years of the 20th century, the US Supreme Court was, for example, resolutely opposed to all measures for employee protection of a kind that had become routine in almost every other civilized country in the world. This is the so-called Lochner era. There was then a change to a period of relative neutrality in the 1930s when the Supreme Court tried to shoot down President Roosevelt's New Deal. A significant change occurred in the 1950s when the US Supreme Court moved to a much more liberal stance, a landmark decision being the decision about segregation in southern schools of Brown and the Board of Education. Now, subsequently, what has happened is that a number of essentially legislative decisions have been made by the Supreme Court. That is, decisions which in any other country would have been made by the elected legislature. The constitutional right to abortion, created by Roe and Wade in 1973, and subsequently major decisions on same-sex partnerships and so on, and indeed homosexuality. Now, I don't object to these decisions as political decisions, but I do object to their being made by courts. What has happened in the last few years, just in the last decade or so, is something different again, because the Supreme Court, which has always tended to make political decisions, is now tending to make party political decisions. In other words, interventions in current politics to support the agenda of the sitting president, Donald Trump. There is every reason to believe that Trump's appointments to the Supreme Court were deliberately made in order to affiliate with people who would behave like that, and that is what they are doing. And that is a profoundly sinister development, even by comparison with the judicial activism of the previous half-century.
You just mentioned Roe versus Wade. That decision was overturned in Dobbs versus Jackson in 2022. Supporters of that decision said the court was simply returning the question to elected legislators, so the individual states. Critics saw it as judges imposing their own moral views. Now my question is this. You have argued that, and I quote you, judges are not and should not be the arbiters of political morality. Was Dobbs versus Jackson an example of judges overstepping that boundary?
Well, to answer that question, you have to go back to Roe and Wade, the case that they overruled. Roe and Wade was, in my opinion, an outrageous interference with what was essentially a political issue for the American public. I personally am not opposed to abortion. I think that a civilized state ought to have a right to abortion with appropriate clinical safeguards. But it seems to me that for the Supreme Court to decide that it's a constitutional right, essentially marginalized, it excluded the opinions of the mass of the American electorate on an issue on which most of them had strong opinions one way or the other. They, in effect, usurped the right of the electorate to decide profound issues of moral legal policy. Now, that, I think, was a mistake, and the reasoning in Roe and Wade was extremely unsatisfactory. Now, obviously, the motive of the judges who overruled it in Dobbs against Jackson Women's Health Organization were motivated, in most cases, I think, by their political dislike of abortion. I don't think that that was legitimate. They didn't express it that way, but it's pretty clear that ever since the Republican Party adopted this as a policy in the late 70s, abortion has been a polarizing issue in the United States, and Republicans have sought to pack the Supreme Court with people who would overturn Roe and Wade, an object in which they subsequently succeeded. So I think that Roe and Wade was a bad decision, but I think that Dobbs was also a bad decision for this reason. The US constitutional law is a precedent-based system, and in general, it is not right to overturn previous decisions of the highest court unless the situation has changed in some respect. Simply to say, well, we would have decided it differently, can't be good enough. Now, in 50 years since Roe and Wade was decided, a right to abortion has become embedded in American law and in American society. It seems to me, therefore, that without a significant change of circumstances, it should not have been overruled. The court did not even pretend that there had been a significant change of circumstances. They simply said they got it wrong in 1973. So we've got two decisions, both of which are utterly deplorable, although for different reasons.
The US Supreme Court justices are appointed for life after very partisan confirmation battles. The UK system looks much calmer by comparison. How much does the design of a court itself shape public trust?
Well, that depends on the wisdom of presidents in their appointments. On the whole, presidents have usually appointed people who they thought were politically, ideologically in line with their own views. But there have been limits to that, and there are two important qualifications that one must make. First of all, presidents do occasionally appoint people who are not in line with their own views, but who are distinguished jurists who will be a credit to the court. For example, Ronald Reagan appointed Sandra Day O'Connor, a notable liberal and a very fine lawyer, as a justice of the Supreme Court. That's one reservation. The second is, and this is perhaps the most important one, that very often presidents have appointed ideological soulmates to the court, but the moment that they get there, they become much more independent-minded. Nobody can remove them. Nobody can get rid of them in any way, shape, or form. Therefore, they start looking seriously at what their duties are. The classic example of this was Earl Warren, whom President Eisenhower in the early 50s appointed to the Supreme Court, especially to ensure that the decisions permitting segregation in Southern schools, racial segregation, were not overruled. And Earl Warren disappointed Eisenhower because when he got to the Supreme Court, he became the leader of the liberal tendency in that court. The earlier decisions on racial segregation in schools were duly overruled in Brown and Board of Education. Now, that's a classic example of the way in which judges tend to change their spots when you make them completely independent by appointing them to a court from which they can't be removed. President Eisenhower subsequently said that he'd only made 2 mistakes in the course of his time as president, and both of them were now sitting on the Supreme Court. It seems to be that it's important that highly ideological presidents should make more mistakes like that. What has happened since then is that presidents have appointed not just ideological soulmates, but soulmates so embedded in their ideology and so committed to the cause that they can be relied upon not to change their spots when they get appointed. An important agent in that process has been the Federalist Society, which was founded in 1982 for the express purpose of training up good, talented young lawyers from an early stage who were sufficiently biased to alter the way in which the Supreme Court decides cases. That, unfortunately, is what has happened. And this is why in one constitutional case after another, the court divides 6-3, with the Republican-appointed 6 overruling the views of the Democrat-appointed 3. That is a profoundly sinister situation for any court to be in.
Some people argue that courts are only stepping into political questions because democratic politics itself is struggling to cope, that judges are filling a vacuum left by weakened legislators and declining public trust. Do you see this growing role of courts as a cause of democratic strain or more as a symptom of it?
Well, I think that criticism has got some considerable force as applied to the United States, because the federal legislature is logjammed. It is very difficult to pass controversial legislation through the American federal system because of procedural rules, primarily the filibuster rules, which make it impossible to get legislation through without a 60% majority. So I think that has created a void in the US legislature. I don't think that's a good enough reason for filling the void with judicial decisions, which simply replace a system which is undemocratic because the legislature can't do anything, with a system that's equally undemocratic because somebody else who is not responsible to the electorate is doing it instead. As regards the United States, I see the force of that criticism. I don't think it's true elsewhere. I don't think that democracy has broken down in my country. I don't think that it's broken down in other countries. There are certainly countries where political divisions make it difficult to get legislation through. An extreme example of that, as we speak, is obviously France. But that is the result of the balance of opinion among the French people and within the French legislature. Sometimes it is difficult to get enough people to agree on a policy to justify giving effect to it at all. I don't think that there's anything wrong with a situation in which you can't do something because there isn't sufficient agreement about it. I do think that there's something wrong with a situation like the one in the United States, where you can't do something because procedural rules prevent the majority from having their way.
In your book, The Challenges of Democracy, you argue that democracy often collapses under the weight of public expectations. What do you mean by that, and how close are we to that breaking point?
We're already there in some places. What I mean by that is that if you look over the history of democracy, which is actually quite short, it dates in most countries from the late 19th century, in most North American and European countries, more recently in other countries. Now, mass democracy generates high expectations of the state. And the fact that, for example, in wartime, the state has been able to achieve extraordinary feats by high degrees of coercion and social organization has tended to increase confidence in the ability of the state to achieve almost anything. There are, however, many things that the state can't achieve, and they include some things about which citizens care passionately. An obvious example is the economy. The states can remove obstacles to prosperity, but the state can't actually create prosperity. People who are suffering from changes in the global economy which are unfavorable to previous economic top dogs like Europe and the United States are intensely angry about this. And what we are witnessing, again, the United States is the main example currently, is a crisis of expectations, a demand that the state should achieve things that it either can't achieve at all or can only achieve at the expense of other things that people value just as much or even more. Now, that is, I think, why we are in the situation we're in the United States right now. I think that people who are made by current social and economic trends globally and who are frustrated by the failure of politicians to achieve the impossible will tend to lash out. And lashing out is the reaction that produced Donald Trump. Now, again, the United States is the extreme example. Is this happening in Europe? Not yet. There is a crisis of expectations in Europe, but it isn't anything like as strong. It is reflected in the rise of populist parties like the Reform UK in the United Kingdom, Alternative for Deutschland in Germany, and the Rassemblement National, Marine Le Pen's group in France, where politicians with very little in the way of a coherent program draw people to their cause, essentially by saying, we're going to smash things up. Now, so far, nobody has actually got into power from that section of politics in the major European countries, but it may happen.
You've said that courts can't save democracy from political failure. So what can? Are there practical reforms you'd support to make democracy more resilient?
There are practical reforms that will achieve that, but they won't go the whole way. For example, in my country, we have a grotesque system, electoral system, which has resulted in a party with about a third of the popular vote getting about 2/3 of the seats in the House of Commons. Well, that's a ridiculous state of affairs, and it's purely the result of the electoral system. Now, that kind of change, amending it to some kind of proportional representation, would represent an improvement, but it wouldn't cure the whole problem. The whole problem is only going to be cured with a significant change in public attitudes. There are many examples that one can give of the kind of changes that are needed. One is the way in which democracies tend to make decisions on the basis of the relative power. Thus, in the United Kingdom, the policies, economic and tax policies, are absurdly favorable to the old. And that's because the old are numerous, relatively organized, and they all vote, whereas the young do not have the same strong record of voting. So we have a serious problem in the UK of generational injustice. Policies which had excluded the young from many social benefits from the housing market, and which have resulted in policies on, for example, climate change that are profoundly damaging to people who are going to be living on this world for much longer than I am. This isn't a peculiarly British problem. The recent Prime Minister of France, François Bayrou, described the French pension system as a system for accumulating debt at the expense of the young for the benefit of the old. He was much abused for saying that, but he was dead right. That's one example. It's a very important example, but there are others.
If trust in courts is like a kind of social contract, what are the basic ingredients that keep that trust alive, and do they also apply to democracy itself?
Well, that's two different questions. They're dealing with judges first. I think that judges lose public support if they appear to be partisan, either in favor of a particular political group or in favor of a particular kinds of policy. I think that we have just about avoided that situation in the United Kingdom, where the judges are in fact highly trusted, partly because the people have an irrational distrust of politicians, and judges are articulate, relatively independent-minded, and have a record of bashing the executive from time to time, which is a spectator sport that the public enjoys. I think that there are places where judges have been much more obviously partisan than they have been in the United Kingdom. In particular, examining magistrates responsible for criminal proceedings in Italy, Spain, and to some extent France, have made choices of cases to prosecute which do seem to be overtly political. And that tends to undermine confidence in judges as a profession. As to democracy, well, democracy is, at the moment, has a very poor press. What we are seeing in successive polls is that a growing proportion of the electorate does not believe in democracy anymore. And what is particularly depressing is that this change of attitude towards democracy is largely driven by younger people, I think for the reasons that I've just described. In a British poll conducted about 5 years ago, more than half of respondents said that they would like to see Britain ruled by a sort of Putinesque strongman who would be at liberty to disregard the rules of the Constitution. Now, I don't know whether you get the same result now, but I think you might well do.
In your historical work, you've studied times when courts were tied to rulers and political struggles. Do you see echoes of that today?
No. The courts in the period of which I'm a specialist, which is namely the Middle Ages, the courts were instruments of royal government. They aren't now, except actually in the United States.
You have also written about the constant tension between law and raw political power. Is today's anxiety about courts just the modern face of a very old problem?
Well, governments don't like being overruled by courts. Governments have enormous power, which is generally not exercised in defiance of courts. President Trump has, in some respects, ignored the courts and certainly denounced them, and that's a very unusual state of affairs. It hasn't happened in many countries.
A last question I have, Jonathan, is neutrality in judging a myth or still worth defending?
Of course it's worth defending. And it's not a myth. I am constantly being told that it is impossible for anybody to approach a legal issue with political implications independently of his own views. Well, that accusation is rubbish. I've been doing it all my life. As an advocate in the courts, I attached no weight to my own opinions. I represented my clients to the best that the law allowed me to do. Judges do the same in a rather different context. Of course, it's possible for them to put their personal opinions to one side. And they do, all the time.
Absolutely. Jonathan, thank you for taking the time to share your insights with us. Your reflections on the balance between law, politics, and public trust feel especially relevant to the challenges we face today. And it's been a real privilege to have this conversation with you. Thank you very much. And to our listeners, thank you for joining us. Conversations like this remind us how much trust matters, not only in our institutions, but in the principles that hold them together. Until next time on Trust Talk.
Thank you for tuning in to this episode of Trust Talk. We hope today's conversation inspired new insights into the transformative power of trust. At Trust Talk, we're committed to exploring trust's role in shaping a better world, one story at a time. If our mission resonates with you, we invite you to support us. Your donation, no matter the size, helps us continue these meaningful conversations. Visit us at trusttalk.co/donate to contribute and be part of this journey. Thank you for listening and being part of the Trust Talk community. We can't wait to have you join us again for the next episode.